I would appreciate your vote.
Hi, I am Jim Marchant, Nevada State Assemblyman for District 37. I would like to announce that I enthusiastically support and endorse Michael McDonald for Assembly District 20. I strongly encourage everyone in Assembly District 20 to get out and vote for Michael. This coming election is crucial for us here in Nevada. It is critical that we send a strong and principled citizen legislator like Michael to Carson City. If we don't, Nevada will turn into California East. Please get out and vote for Michael McDonald. Thank you.
This is the matter of McDonald versus McDonald, D 15-518905D. This matter was set for 9 o'clock. It's now 5 after. Present is the plaintiff and counsel. Counsel, your appearance for the record. Good morning, counsel. Are you surprised that the defendant is not here?
Yes, I am.
Okay, there's a few things that are on. Mr. Gabados filed a motion to withdraw that's set for March 16th. I'm unsure if he's going to be here today. Have you spoken to him?
I haven't spoken to him at all.
All right, and then I see you filed a motion in limine that's set for 4/17, but certainly I'll hear that today. Why don't we have a seat? We'll stay on the record. We'll give them an additional 15 minutes and see if anyone appears.
While they wait, Dr. Business would like to show you a town council meeting in Nevada. Hop in.
Hi, my name is Michael McDonald. I'm the Assembly District 20 candidate, member of Veterans in Politics, Restoring Freedoms, director of Restoring Families, and several other groups. I'd like to give some testimony as to the despotism that's occurring in our family and our criminal courts. Our criminal courts, through traffic violations, are enslaving the people and taxing the most vulnerable citizens. I've got a story of a few veterans that have been thrown in jail. They usually never went to jail before, had no criminal record. They get thrown in on a simple traffic violation or a small accident. They go into the whole booking process, which is devastating. They have to go into a fish tank of 20, 30 people, where I know one gentleman, he had diabetes. His legs were swelling up. He wasn't getting medical care. They kept him in that fish tank for over 48 hours, and he was swelling up. He had to have medical attention after the fact. You have to wait in that fish tank for almost 2 days just to see a judge or to get a violation. There's another kid, a 19-year-old kid, rolling up in a big truck. He got in an accident. The cops rolled up, thought he was DUI, took him to jail. The kid had never been to jail before, had no criminal record, and they throw him in jail in a tank to observe him. He then plays around, he doesn't know what's going on, gets thrown into an isolation chamber where he stays there for almost 6 days. He tries to commit suicide by wrapping a sheet around his neck. They then take him there, strip him naked, put him in an observation cell. The officers then go and beat him up and spray him with mace several times. Now this is just tyranny that's going on, and the amount of money that they put on impose on these people. These citizens that have never been in jail before, had no criminal record. It devastates lives. They lose their livelihood. They lose their house, their kids, their family. And if we don't fix this now, it's going to cause a rippling effect. Just to go and fund what a new a new courthouse that's coming up. It's ridiculous. We need to address the problem and stop enslaving our own citizens. So I asked this committee to please stop throwing people in jail for simple violations or traffic infractions, and also for low-level crimes that they shouldn't be in jail for. It devastates lives and is causing so much havoc when you get stay-out-of-trouble orders, or you get one order, or classes you have to keep going back and forth they're getting charged parking tickets, and it just insinuates the recidivism rate, and then constantly going back to the court to make money off of these people.
This is Michael.
Mr. McDonald, we're on the record. This matter was scheduled to begin at 9 a.m. Council's already made their appearance for the record. I've noted for the record there are two matters pending. First, Mr. Gabato's motion to withdraw as counsel, but he's not here yet. Do you expect him?
Judge, I don't recall if he's going to come or not.
You don't recall? You don't remember, or you don't know?
I don't know, Judge. I actually ran into him on Friday, and he said he'd possibly be here. So I'd like to address that matter for trial.
Today we are in family court. This isn't a trial, but a hearing to modify custody. Requested by Michael.
Go ahead.
Well, first of all, Judge, I can't afford an attorney. I'm here representing myself, as my financial situation cannot afford me an attorney, and we do not have due process of law, which is the Sixth Amendment, which is constitutionally protected.
This is how Michael talks when he is trying to sound like a lawyer.
Alex Gabato has not filed anything in my case, Judge. He told me he would do trial. I've been waiting for months for something to be filed. Nothing's been done. So I'm here representing myself today. I'll do the best I can. I would ask that this court grant me an attorney as pursuant to NRS 128.100.
Michael has requested that the judge assign him counsel, free of charge.
That an indigent litigant can ask for an attorney, especially in regards to parental rights being terminated, which I would say over a year without seeing my own children constitutes that.
Go ahead, counsel.
Yeah, Your Honor, we were here back in September on defendant's motion to modify. It was a motion for a lot of different relief. At the September 27th hearing, defendant's counsel conceded that it was simply he wanted to convert it to a simple motion to modify. All the other issues were dismissed, and at that time they requested that the matter be set for evidentiary hearing. That's when Your Honor, on September 27th, issued a case management order with very specific deadlines for designating witnesses, which was January 30th. A discovery cutoff was February 14th, and pretrial memos with a list of witnesses and exhibits was all due by March 6th. Throughout that 6-month period, defendant did absolutely nothing.
Michael has done nothing required, has no exhibits, evidence, or lawyer. Making it through this first part will be the hardest.
Judge, may I speak to that?
I'm going to give you an opportunity now. What I'd like to do, so that you both understand, we're not going to interrupt each other all day. I will give you a chance to respond to everything, Mr. McDonald, but you will not interrupt me, and you will not interrupt counsel. I expect the same from counsel. All right, Mr. McDonald, what is your response? He's saying that you haven't made any mandatory disclosures. You didn't file a pretrial memo on time. You didn't give us exhibits on time. This is, trial by ambush. At the last minute, you provide us documents.
So, Judge, I was advised by counsel not to file anything, not to do anything, so I didn't. I was waiting on him. I was completely confident in his abilities to prepare for trial, as I'm not qualified for that. So I didn't file anything. I was following advice. I was following all orders of this court to the best of my ability, and I found out last minute that he's dropping me. So I wasn't able to afford him or any other attorney within such a short amount of time, and without all my monetary resources being drained by lies of this court, or lies of opposing counsel.
This is how Michael is. He has come to court this morning with the express intention of harassing his ex-wife. This has been going on for years.
I would like to say that that my case would consist, as I filed this motion, that all the previous motions that I filed, I want to address is in regards to custody, assets, and child support. And I would like to address those things today in court, and my case will consist of a sworn statement to the court of all the matters in my case today with the exhibits. And which I did file, I did scramble to file a pretrial memo and get that prepared with the exhibits. I did my best to follow the orders of the court. I did not understand how to do discovery, so plus I was advised by him not to file anything. So
I would like to introduce the judge.
You two can have a seat.
So Judge, can we address the issues of custody and then property maybe at a later time then?
All right, have a seat, sit down. I'm going to tell you how we're going to proceed today. Your motion, your request, this evidentiary hearing is set to modify custody. At the end of today, I will make a determination as to that request and that request only. I will give each party today 3 hours to present their case. The rule allows me to do that because you didn't do anything. You didn't make any mandatory disclosures that are required by the rule. You didn't give us your pretrial memo, counsel in the court, well in advance. You didn't drop off the exhibits as the court ordered, and counsel abided by that order. However, I'm going to allow you to present whatever you're going to present, and I will give it the weight that is appropriate.
This is why Michael was not permitted any contact with Candice or their children.
I ordered joint legal custody and primary physical custody to mom and gave dad visitation every other weekend. Among other things, I found that Mr. McDonald committed multiple acts of domestic violence, including pushing Mrs. McDonald down to the floor, handcuffing Mrs. McDonald, restraining Mrs. McDonald against her will. Further, Mr. McDonald prevented Mrs. McDonald from leaving their residence to obtain medical treatment for their child despite medical advice. Mr. McDonald appealed. The Nevada Court of Appeals unanimously affirmed the judgment of the district court and remitted or issued. November 29, 2016, just months after the final decree had been entered, Senior Judge Kathy Hardcastle heard Mrs. McDonald's motion to modify custody and visitation. Judge Hardcastle was extraordinarily concerned about Mr. McDonald's behavior in court, the domestic violence arrest, and other issues. Judge Hardcastle modified visitation to supervised visitation. On May 2, 2017, the court temporarily granted Ms. McDonald sole legal custody, primary physical custody, as she had always had primary physical custody, and supervised visitation was temporarily suspended pending Mr. McDonald's release from custody. Pursuant to McMonigal and Castle, the court will not consider any facts or circumstances that occurred prior to the last custody hearing. The last custody hearing date was August 16th, 2016.
The judge has been dealing with Michael for years.
What that means is the court cannot consider any fact or event that happened prior to that date. How many witnesses do you have today? Who do you plan on calling to testify?
I do plan on having her parents be witnesses. I do have other witnesses that were able to make it, as my brother is off on drill. My mom is, most of my families have prior issues or employment they were not able to do.
So just you and her parents, is that correct?
Judge, I could bring an army of people in here to attest to my character and to my...
Okay, is that what you're doing today? I need to know just so that I can know how we're going to spend our time this morning.
Another burn from the judge. Michael has nothing but excuses all the time.
I don't think that would be warranted, Judge. I could have, if you think it would bear weight to your decision, I will summon a bunch of witnesses. But if not,
this is your case and your motion, so you decide what you would like me to hear.
I don't want to waste the court's time in bringing all that.
Okay, so what's the answer to the question? How many people do you have? 3? You and her parents? Is that right?
Me, her parents.
Okay, so 4.
Other witnesses that are present.
Who's the other witnesses that are present?
Her father, her mother, and
okay.
Even Kendra over there. And
Who's Kendra?
Even Kendra over there isn't safe.
even Kendra over there. And
Who's Kendra?
Kendra's the
Okay, is that her friend or her sister or who is that?
friend that can attest to us living life together. So, and to the stuff that happened within our divorce or
Things that happened in the divorce have nothing to do with the hearing today, an order to modify custody. Michael uses this as a weapon to drag people to court.
Okay, do you remember that I just said I'm not going to hear anything that happened before August 16th?
And she would not be able to.
Okay.
But her boyfriend would be able to.
Okay, all right. These are the last times I'm going to remind you of the rules, okay? I'm going to get, if you spend your time telling me about stuff that happened in 2008 or 1986 or whenever it is, if it's before that August 2016 date, the court's going to filter it and is going to apply McMonigal and Castle appropriately. So I've told you multiple times about the rule. I've corrected you. I've asked you. So you spend the time as you want. Counsel, do you have an opening statement that you'd like to make today?
Yes, Your Honor.
Oh, Mr. Gabato's here. Good morning, Counsel. How are you? We've started already.
This is why Michael doesn't have a lawyer.
We were set to start this morning at 9 o'clock, so we've dealt with some issues. Your motion to withdraw as counsel is on for today. Is there anything you want to tell me in reference to that?
Well, Your Honor, I think that defendant has a right to, he's entitled to his own case. We have a disagreement about how that case should be presented. And it's a fundamental disagreement. I can't assist him anymore, given what the direction he wants to take. He wants to persist in that direction. And so for that reason, it has to withdraw and allow him to present his case.
All right. Mr. McDonald, do you have any objection? Anything you want to say
Yes,
in
I would
reference?
object to that, Judge, as I prepared the best to my ability, but I would ask that a Ferreira waiver be put in place that he can stay on as co-counsel to help assist in attorney duties to provide assistance to counsel, as I don't.
You're asking me to do a Ferretta canvas?
It's Ferreira canvas for the attorney to stand as co-counsel or as stand by as co-counsel to assist in presenting my case and asking questions, as I'm unable to ask questions of myself.
You want him to act as standby counsel?
Yes, Judge.
Mr. Gabato?
It's up to you, Your Honor. What to say about that?
Use the assistance.
Lots of lawyer words, no lawyer brains.
Here's the deal, Your Honor.
So generally, that is, well, not generally, all of the time, those cases, standby counsel is afforded when litigants, specifically criminal defendants, have a right to counsel, but want to represent themselves and don't want appointed counsel. And so the court is extraordinarily concerned about their ability to represent themselves adequately, will appoint standby counsel. That's not what we do in civil matters. You have no right to an attorney. The county is not going to pay for somebody to be your attorney. This is your motion to modify custody.
The judge is starting to get frustrated. This is to change the custody agreement.
So counsel has indicated that there is a fundamental disagreement between the two of you. It sounds as like, from what counsel is telling me, that this impacts his ethical duties of candor towards the court and his ethical duties about what type of evidence and the truthfulness of the evidence he's allowed to present. That's what concerns me. If I were to appoint counsel as standby counsel, I'd be ordering him to make some ethical decisions and do something he's not comfortable doing. He said it in his motion. He said it to the court. I think he's trying to be extraordinarily professional and not implicate any attorney-client information, confidential information that perhaps has been shared between the two of you in preparation for today. I'm not going to order Mr. Gabato to do that or violate his ethical duties.
Mr. Gabato cannot represent Michael because of the things Michael wants to say and do in court.
And that was what I was going to suggest to the court, suggest Mr. McDonald that if he accepts that, that's probably in his best best interest. If you can't do that, then I have to step out.
I understand, counsel. Mr. McDonald, anything?
Judge, I would ask that Mr. Gabato help in the direction or the assistance of presenting the trial cases. As I have not.
I just indicated I'm not going to do that. Mr. Gabato has ethical duties and rules that he has to abide by as an officer of the court. What he has told me here in court, what he has written in his motion, is that there's a fundamental disagreement between the two of you. He has a duty of candor towards this court. He cannot suborn perjury. And so, I'm not going to order him, if you two have a fundamental disagreement, a fundamental difference, he cannot act as standby counsel. I can't order him to do so. This is not a criminal case.
The hearing hasn't even started yet. Michael's ridiculous demands will continue.
Judge, I would ask that there should be afforded assistance of counsel when in matters of this magnitude of stripping of parental rights for over a year for property that's in excess of $50,000 or more, $100,000. And I ask this court that I have that assistance of counsel, and that there isn't a fundamental difference. There is a duty to the court when there is an attorney that says that they will do their
Michael will now insult Mr. Gabato and the court.
Due diligence in your case, and then to not be afforded that time to scramble at the last minute or not file anything. There should be a duty, and attorneys should be held accountable for not.
That's between you and counsel, and I don't have jurisdiction over that. I am not going to continue today. All right, this is your motion. After request for continuance, and multiple appearances by multiple attorneys, this case, these children, you deserve finality. I'm giving you an entire day. The next entire day I have available is in August. We're not going to wait that long. We'll do it today, all right?
Mr. Gabato has an opinion of Michael after being insulted.
And I can see where he's coming from. However, you two disagree about the fact that you have a fundamental disagreement. You say you don't, he says you do. So that means you do. All right, thank you, counsel.
Real quick for the record, that what he said kind of touches on that fundamental disagreement. He wants to take this in a direction that I'm just not willing to go. He wants to argue about his rights, his constitutional rights, and his understanding of his constitutional rights. His understanding of his constitutional rights, what he wishes his rights to be, rather than what they are. And I just can't take it in that direction.
Judge, I'd like to rebut.
Including, in addition to what you've already stated.
Michael is like a sovereign citizen, but he does it in an odd way, by stammering and fumbling.
I just want to present evidence of all the things that I've done up to this, and what's in the best interest of my children, and what our children, and what I've done. I've followed all the court's order. I've done my best to my ability to redeem myself, to show this court that I've done everything possible to be able to see my children, and to be the best co-parent and father that I can be. And I'd like to present that to the court. I also would like the court to consider that my criminal charges are on appeal. And I filed my criminal appellate briefs, and I'd like the judge to review those and take a look at that and give that weight as well. As I can attest that and I've even though I have 3 years to do certain things, and I've done my best to follow those orders and follow the advice of counsel, which I've been doing to the best of my ability.
Every single part of what Michael just said was bullshit.
All right. Thank you. We're moving forward today. Thank you, counsel. I'm granting your motion. You'll prepare an order, counsel. Thank you. All right. Everybody have a seat. I'm sorry, I forgot where I was. I was asking you if you had an opening statement or you'd waive opening statements today.
I would like to make an opening statement.
Go ahead, counsel.
Do I go first on that, Judge?
You're right, Mr. McDonald. You do go first. Go ahead, Mr. McDonald. Make an opening statement. An opening statement is not argument. It's a list of things that you are. Tell me what you're going to prove to me today and what you plan on showing through the evidence. Go ahead.
And now it begins. Michael McDonald files empty motions to drag everyone into court. This wastes everyone's time and money. This is the contempt of Michael McDonald.
So, Judge, like I said, I'm here representing myself as my financial situation cannot afford me as attorney. I said I would like the assistance of counsel, as I am not yet an attorney. One day I hope to strive to become one.
Michael will not become a lawyer.
Learn this process. My case will consist of a sworn statement to the court of all my matters in this case, in regards to custody, property, and child support, as I originally filed those motions and did not agree with counsel to preclude that. I would like the court, if not to see the custody, the property matters that be trailed at some other date or some other time that we could address that, as there's significant property issues and orders of this court that were not followed per the divorce decree in regards to selling the house and the improper sale and marital waste and assets that were stolen and burglarized from the house.
Michael will accuse his ex-wife Candice of doing all of those things and more. Candice is a strong woman, an elementary school teacher, a mom, and an angel.
So I would like to bring up those issues, and I've also included that in my exhibit list. So I would like to go first in this case and prove to the court what happened and prove the case that's at hand. And the major thing is that I've had zero contact with my children almost 450 days.
Michael thinks he's a good father. He isn't.
I'm a loving and caring father. I've done my best to follow these court's orders and obey all the orders that were put in this court and in municipal court. I would like to show the court that this is a case of extreme parental alienation and pathogenic parenting, that I've done my best to follow and comply with all orders of this court, and that I could show the court how much I've learned in so many things. So much has happened in the past year that I'd like to present. Over the past year, I've learned so much. I've read over hundreds of books. I've
reading hundreds of books. Check.
Completed almost 25 domestic violence classes, which I've learned that everything is domestic violence.
25 domestic violence classes. More on that in a minute.
I had no understanding of some of the things that are or aren't, and I would like to present to this court that there is a major issue of fraud upon this court and lies and deceit by counsel here. And I would like to present those evidence that I have and show this court that I am a good and loving father, that there's no warrant for keeping children from a loving parent for over 450 days without the proving of unfitness.
The proving of unfitness. You'll hear lots of terms like that.
Judge, I've never been proven unfit. I am a fit and loving father. I've taken well care of my kids. I've also had them for over a year while up to trial of October of 2016 before the series of unfortunate events that happened.
The unfortunate events were Michael being arrested, charged, or in breach of court orders several times. He secretly installed a GPS tracker in Candice's car. He showed his young son that he could track mommy.
Where my attorney took his own life, and I scrambled to try to understand this court process and try to proceed. Judge, this is the most emotional time. They say that divorce is worse than death. I'd like this court to take that into weight, that a divorce is an emotional matter. It's a matter of the heart. And when children are separated, when they're not able to see their parents, that it causes deep-rooted psychological issues, which I'd like to show in my exhibits that I've included as well. I have completed counseling, Judge. I've been seeing them through, which I will show through my exhibits and through this trial. I've done.
Defendant did absolutely nothing.
So many things. I've done a psych eval just to prove to the court as well, to show that this court that I'm of sound mind and of sound body and mind to.
Michael hasn't done anything the judge asked. He did it on purpose to slow things down. This is and was a scorched earth divorce because of Michael. This is his fault.
Of sound body and mind to raise and love my own children and be in their lives and be a good co-parent. I've taken parenting classes and divorce care classes at my church that I could show evidence to, and I'd like to attest. I'd like to also prove the fraud, the baiting, the entrapment, the the complete lies, the poisoning of the well that her counsel, by her counsel, have also committed, and extreme fraud upon the court, which and upon the rights of this court in regards to property and custody.
Michael is angry about the house. It was sold. He believes several conspiracy theories about that, and other things in this case.
You ask that you judge take all this into weight, and that the court grant joint physical custody, as I have had our children for over a year pending trial. I was well able to take care of our children. But now the house that we raised our children in has been sold. Their toys and their furniture have been thrown away in a dumpster.
Michael has just accused the mother of his children of throwing the kids' toys in the dumpster,
along with the items that were stolen from outside the property. Judge, you put in orders that I did my best to follow, that were put in place, that were I perceived as contradictory. I could not follow. I've learned so much that following orders are, and so many things that...
Michael ran into the children's daycare to take his daughter out unexpectedly. He was not supposed to have contact. Michael grabbed the wrong child, a sleeping little girl. Everyone was terrified.
And things that what I can and cannot do, and things that I really would like to show and prove to this court today. So I ask that I may have the ability to present this case and to be able to show the exhibits, that you take this into weight. And I want the court to understand that it's not in the best interest of children or parents to be alienated, be separated from their parents. As it's not best to not be able to see them, not to withhold love from a loving parent.
Sometimes courts step in so they can withhold crazy from a crazy parent.
To be able to not be in their lives, to not be their coach, not be their steward in life. So I ask this court today to take those things in merit, and to give that chance, and give the weight of this court, and to redeem myself between this court and expose those lies and deceit and slander that was caused by the plaintiff and her counsel. I think that's it.
Now an actual lawyer will take Michael apart. The truth is much, much worse.
This is the defendant's motion. It is his burden to show that there's been a substantial change in circumstances, and that it is in the best interest of the children for there to be a modification of custody. We intend to introduce evidence to show that Mr. McDonald has been found guilty of violating a restraining order. He's been found guilty of battery domestic violence. He pled no contest to 2 other instances of violating a protective order. And throughout the entirety he's been unable to comply with virtually any order issued by the court. He still, to this day, refuses to take responsibility for his own actions. He refuses to accept that change needs to be made before he can be considered a suitable parent and custodian for these children. There's been a lot that's happened out in social media and on YouTube videos that just recently were removed and we lost access to, that were posted by Mr. McDonald, that just demonstrate that he has not taken the steps necessary to change, to become a suitable parent. He mentions that there was that he did a psych eval. This court on 2 different occasions, once in November and once at the September hearing, ordered him to get a psych eval in preparation for this hearing today. That has not been completed.
Objection.
Michael isn't who he says he is.
And there's just no evidence that Mr. McDonald can produce that will show that it is in the best interest of the children for a motion to modify to be granted at this time.